what are the barriers to growth or blockers for innovation? And on the legal front anyway, Peter being our expert, we've seen Perplexity and others in the news getting in a little bit of trouble about using, improperly using robot.txt, potentially in their scraping of content in their LLMs. We've seen cease and desist orders. We've seen others licensing data perhaps for strategic reasons, to put pressure on others, as Richard has talked about with some of us before the panel. So I'm curious, Peter, what you think about this, and is there any parallels to the LinkedIn case, which I've heard you talk about a lot in the past?
Thanks. So I think there are some. Look, the whole robot, we know if we look at any website terms of use, they all say you can't crawl, harvest, scrape, use robots.txt. 95% of websites say that, maybe more than that. And so we're in the early innings of what you just said, which is we know everyone's scraping and we know they're misappropriating the information. And what I mean by that is they're just taking it in violation of the terms of use. I mean, it seems pretty clear that that is happening. The question is, what will be the consequence? I just think it's too early to say. I guess there's two possible solutions, and they're not mutually exclusive. One is just a commercial solution, right? There will be licensing arrangements where folks license, and so they're not misappropriating anymore. And then that whole LinkedIn part, that Computer Fraud and Abuse Act case that we worried about, which was you're misappropriating, that analysis will go by the wayside. The other, of course, is for the courts to figure it out. Just like with the 𝐒𝐞𝐫𝐢𝐞𝐬 LinkedIn case, which took a long time to wind its way through district court in California, then the Court of Appeals in California, and then to the Supreme Court. This will take years to wind its way through our court system to get a real answer. My guess is you will get multiple conflicting answers, as you often do when something is new, from mid-level court, district courts around the country, as to whether or not the LLM scraping, when in violation of the terms of use that prohibit robots.txt, constitutes a violation of some analog to the Computer Fraud and Abuse Act. I just don't think we know yet, but it's just based on what you're all saying, and you're much more expert in the technology, it seems pretty obvious it is, right? That information is being misappropriated in violation of the terms of use. But I guess if you apply that to the end of the earth, then a lot of LLM the use case is undermined, and that doesn't seem like a realistic solution as much as I look at the law and I say, well, yeah, you're misappropriating, Rod.
Yeah, Richard, go ahead.
Roger, it seems like there might be two issues here as well, which is there's the copyright, the IP violation, and then there's the terms of use violation, the Computer Fraud and Abuse Act. So I'm just curious, Google has said they don't honor the robots.txt anymore. So is that even a relevant document?
You're still, especially if you're clicking through, right? We always like a click through better. It becomes a little more easy, a little easier, a little more enforceable. If you're clicking through, you're accepting the terms of use. We all click through every day. We never read anything, right? We just
so then we're all committing computer fraud if we're downloading that content.
Maybe fraud's a big word, but you're certainly misappropriating information in violation of the terms of use.
Right.
Maybe but it just seems, and I think you were going to talk about this, it just seems impractical to think that we're going to enforce that and then no one's going to be able to scrape.
Yeah, and I think the enforceability piece is the key word.
No question. And if you're clicking through, we always think it's a little, the argument on enforceability is stronger if you say someone clicked through. But even so, we all know we click through, we never read it.
Right.
Never.
Roger?
I guess the other thing I wonder about,
informed.
Sure.
if the way that I think we all use LLMs is not, we don't rely on the content in the model, I hope not, for anything. Because of the risk of hallucinations. What you're really using it for is simply its knowledge of language.
Right.
And so that content, it seems to me, if scraped from websites, you're never really querying the content itself, but just using its knowledge of language and applying it to your own content. So I wonder about that. And the other thing is that if we wind up with a framework where these firms like OpenAI, et cetera, are paying licensing agreements to every major content provider, I just wonder what the economic model would look like. I mean, I'm not sure how they would survive.
Not everybody can afford that.
No one would afford
Really quickly on LinkedIn, the reason we cared about LinkedIn so much is because we're about insider trading. It's the most consequential pitfall here. And just very quickly, in order for someone to be convicted of insider trading, you have to have information that's material, information that's non-public, and information that they, in this example, misappropriated. So here, with the crawling, clearly it's misappropriated. The terms of use say what they say. Arguably it's material, maybe it's not. I think it depends, of course, on what you're scraping and how much it factors into your financial decision-making, your decision to purchase or sell a security. But if it's all public, if you're not putting in a username or password, and that's why we cared so much about LinkedIn, because what the proposition LinkedIn stood for in the context of insider trading was, if you're not putting in a username or password, well, then it can't be insider trading. You might be misappropriating the information, and you probably are, but there's no securities law violation, insider trading violation, because, well, it's public. Anyone could do that. Now, anyone can't actually do it because people, there's a continuum of competence, but anyone could do it.
Right, right. And so, Peter, just curious your thoughts. Do you have any thoughts on the legal stuff, or in more broad sense, the constraints or blockers that you're seeing in using LLMs, before we get to something a little more positive on the opportunity side?
I mean, I pick up the one quick comment, maybe explain why I disagree. We're not using large language models only for their quote language ability. In the same way that blind people understand glycerin glint and so forth, and transparency, language models understand the world, and there's copious evidence for the fact that they can map it. So there's, how many of you use the Barra factor model, by the way? All right, it's a stalwart of the industry, right? But I could show you very easily that I can take that, I can ask an LLM 5,000 questions about whether it thinks company A is similar to company B, and I can outperform Barra out of sample. Really easy. So we have to be careful when we say they just know language. They don't just know language. They know a lot.
Roger, I'll maybe give you a chance to respond to that, and maybe you could talk about some of the constraints that you've seen, whether it's technology, whether it's legal,